Imagine for a moment that you wake up one morning, walk out to your own driveway, your own land, your own private property that you pay taxes on and legally own, and you decide to install flashing red and blue lights on your gate, on your private security vehicle, or even on the roof of your personal garage. And you think to yourself, I am on my own property. Nobody can tell me what to do here. This is my land and my right. But then, within hours, a police officer is standing at the edge of your property, looking you in the eye and telling you that what you have done is illegal. And the most terrifying part of this entire story is not the officer standing at your gate. The most terrifying part is that the officer is completely correct, and you had no idea because nobody ever sat down and explained this to you slowly, clearly, and honestly. And that is exactly what we are going to do right now, because this question, can I use police lights on private property, sounds simple on the surface, but underneath it is one of the most layered, misunderstood, and genuinely dangerous legal questions that everyday property owners face without even realizing it. So stay with me, because by the end of this video, you are going to understand not just the answer, but the reason behind the answer, and that reason is going to change how you think about your rights on your own land forever. To understand this properly, we need to start at the very beginning, and the beginning is this. In the eyes of the law, not all lights are created equal, and the single most important factor that determines whether your lights are legal or illegal is not where you place them, it is not your intention, and it is not how many acres of private land surround them. It is color, specifically the combination of red and blue, because in almost every state across the United States and in most countries around the world, red and blue flashing lights together have been legally designated as the exclusive signal of law enforcement authority, which means that the moment you flash red and blue lights in a pattern that resembles emergency signaling, you are entering territory that the law has reserved specifically for police, fire, and emergency services, and private property does not create an exception to that rule, because the law was never written to control what happens only on your land. It was written to control what the public sees from outside your land. Let us make this real with an example, because examples are where understanding truly lives. Imagine a man named Marcus who owns a private security company and operates entirely on his own privately owned industrial property, a large fenced compound with warehouses and storage units. And Marcus decides to mount red and blue flashing strobe lights on his patrol trucks to make his operation look more authoritative and to deter criminals from targeting his facility. Marcus never drives these trucks on public roads. They stay inside the compound at all times, and Marcus genuinely believes that because his entire operation is on private property, he is operating within the law. But here is what Marcus does not realize. Those red and blue lights are visible from the public road that runs along the fence line of his property, and every single night, drivers passing on that road see the flashing lights. Some of them slow down, thinking there is a police checkpoint, some of them pull over in confusion, and one night a truck driver sees the lights, assumes there is an emergency ahead, and brakes suddenly, causing a chain reaction accident on the public road. Now, Marcus is not just facing a question about lighting laws, he is facing civil liability for an accident he indirectly caused from inside his own private property because his lights reached beyond his fence and created a public safety hazard. And the law does not measure danger by where the light source sits, it measures danger by where the light lands and what it makes people believe. This brings us to the second factor, which is purpose, and purpose matters enormously in how law enforcement and courts evaluate your use of lights on private property. If your lights serve a clear, demonstrable, non-deceptive safety function, such as marking a hazardous drop-off at the edge of a private loading dock, warning workers about moving machinery in a private facility, or alerting authorized personnel to an access gate on a private road deep inside your land where no public road is visible, then the legal risk is significantly lower because you can show that your lights are functional, location-specific, and not designed to create any impression of law enforcement authority. But the moment your lights face toward a public space, mimic the flash pattern of emergency vehicles, or serve no clear safety purpose beyond looking powerful and official, you have crossed into territory where the law is very unlikely to protect you simply because the ground beneath those lights belongs to you. The third and critically important factor is jurisdiction, meaning the specific laws of your state or country, because this area of law is not uniform. In states like California and New York, the statutes around unauthorized emergency lighting are broad and aggressively enforced, and you can face misdemeanor charges simply for possessing red and blue lights in certain configurations, even if you have never activated them on a public road. In other states, the laws are narrower and focus primarily on use while operating a vehicle on a public highway, which may give private property owners more room to operate. But the danger of assuming you live in a permissive state without actually verifying the law is enormous, and the safest alternative in almost every jurisdiction is amber lighting, because amber or yellow is universally associated with caution and slow-moving equipment rather than law enforcement, making it legally permissible in most private security, private construction, and private property management contexts, without the same legal exposure that red and blue carry. So here is the final truth that this entire video has been building toward. Private property is a powerful legal concept. It gives you control, it gives you rights, and it gives you protections that public spaces do not offer. But private property has never meant invisible to the law, and it has never meant that what you do on your land has no consequences for the world beyond your fence line. The law of emergency lighting exists not to punish property owners, but to protect the public from confusion and danger. And the standard the law uses is not what you intended, it is what a reasonable person standing outside your property would perceive when they see your lights. So before you install any emergency-style lighting on your property, research your specific state laws, evaluate whether your lights are visible from any public space, choose amber over red and blue whenever possible, and if you are ever uncertain, consult a local attorney before you install a single bulb, because knowledge used before a mistake is called wisdom, but knowledge used after a mistake is called regret. Protect yourself, protect your property, and protect everyone around you. Share this video with someone who needs to hear it, because the law will never warn you first, but today, you have been warned.